coba kuat kan Andrew lah Yes, ma'am.
Your Lordship, in respect of item number 6 and 7 from the hearing list, as the leading counsel, Mr. A.R. Mulhoja, is out of station, may the matter be listed after a week.
6 and 7, the matters which are not taken up, we will pass orders, don't worry. Okay? Do not worry, we'll take care of that. Just remind me, that matters. Next hearing list you can put.
Lordship, with regard to item number 3 also.
Whichever matters are not taken up, we will pass orders, don't worry.
Obliged.
Daily list for admission, item number 1.
Yes, madam.
My lord, a new assessment has been done regarding the instant contempt case. We are waiting the results of the assessment, my lord.
It's not confirmed. There were other matters also. Madam Dinari was that day. When we have fixed those matters?
This case, my lord.
No, not this one only.
Yes, my lord.
The other day it had come up.
Yes, on Monday.
Okay.
It was taken up on Monday, but I
So,
was on leg.
what happened? Have you approved the rates? Madam?
My Lord, Miss Mary is
Ah,
appearing.
yes, Mary.
My Lord, I'm appearing on behalf of the DC IGO. The steps was taken by the state respondents. However, in terms of the order that was directed, assessment has to be made as per the 2013
13
Act. However, by mistake, they have made the assessment as per the old Act.
Have you
And
made the
then,
reassessment?
Yes. Now, a new assessment is made, and then the matter is sent to the concerned authorities for payment.
Okay.
My lord, this I will file an affidavit if permitted, my lord.
So once that it has been done under the 2013 Act, what remains?
The outcome, my lord.
Outcome will come. That outcome is not here. It's only that they shall make a requisition to the state government through
Yes.
respond number 1, 2 and 6 for acquisition of the said portion of the land. Thereafter, the land should be acquired as per 2013 Act.
Yes, my
Now the 2013 Act assessment has been made.
Yes, my lord. As the learned counsel has submitted, if she may be allowed to file her
No,
affidavit.
we take her words. Why should I disbelieve her?
Because I have.
We'll
to
record
say-
her statement and we'll close these matters. Yes. You are also affected party. Oh, this is a different case. Oh. Yes, madam. When can you file the affidavit?
My lord, if I may be given
No,
1 week-
affidavit means full compliance report I want. I don't want an affidavit.
Yes. On the part of the DC only, on the part of the DC full compliance, we can file.
No. Now the matter has gone to the government for approval.
Yes.
Then it will go for payment to the other acquiring authorities, acquiring department or organization.
Now, the DC is awaiting payment.
Okay. Miss Mary L. Kiante, learned government advocate, appearing for the respondents number 8 and 16, submits that the assessment has been made in terms of the Puranamtu Likhiriba Land Acquisition and Rehabilitation Act 2013 by the Deputy Commissioner, by the Jurisdictional Deputy Commissioner, and the same has also been forwarded to the competent authorities for approval, right? Madam, forwarded for approval.
Yes,
She
ma'am.
submits that she be given a week's time to file an affidavit in this connection. Prayer is not objected to by the learned counsel for the petitioner. A registry to list this matter again on 26/3/2024. In the meanwhile, the Ms. Mary Alkente shall file the affidavit as undertaken by her.
Oblige.
Item numbers 2 to 6.
Identical situation, Your Lordship. Location different, but situation is identical.
Orders are same. This is Siha.
Yes, Your Lordship.
Yes, madam, what is happening?
Yes, my lord, I believe that my assistant has given the preliminary notification. The preliminary notification was issued on 12th January 2024.
What are the case numbers involved here?
In respect of all the cases. And my lord, I believe that my letter dated 30th January 2025, I believe that,
It's here.
yes. All the cases that is affected with that preliminary notification is tabulated here, my lord. The award was duly approved by the government by this letter. And
Not by the government, by the, government approval, okay.
yes, it was approved.
So
by
what is
the
left here?
government.
Payments have been made, now it has been sent to that, the concerned acquiring authority.
Yeah. The acquiring authority, BRTF, were informed about this. On
Where is the order?
December,
Where's the order?
my lord, order will not be there.
No,
Order
no.
will not be there.
No, the order which, violation of which has been.
Yes, Your Lordship. In my contempt petition, page 12, Annexure 1, the relevant paragraph is at page 23, para 10. Your Lordship has para 10. It says the payment of compensation shall be completed by the respondents within a period of 6 months. So the direction is twofold.
So the last part is there.
Last part is there.
Miss Eke naam, huh? Mary, so learned government advocate, appearing for the respondents.
My lord, in this item number 2, I appeared on behalf
For the
of...
government, for the state respondents. Submits that in the present, in the assessment of compensation in respect of the land acquired and involved in the present contempt petitions have been approved by the government via a communication dated 15/1/2025. Full stop. Thereafter, the jurisdictional deputy commissioner has forwarded the sanction to the border roads, BRTF authorities for further action and release of funds. Full stop. She submits that the funds are yet to be released and prays that the matter be taken up after 2 weeks, enabling her to bring on record the updated position in the matter. Full stop. In view of the above development, this court is of the considered view that further 2 weeks' time is be granted to the state respondents to the Learned Council for the state respondent, appearing for the state respondents to update her instructions and apprise this court of the further developments taking place in the matter. Accordingly, the registry to list these matters again on today is 11th.
My Lord. 12th of March.
12th. On 1st, oh no, 2nd of, 2,
My lord, first is... Yeah, yes.
First, on 1/4/2025. This will cover 2 to 6, right?
My Lord. Deeply obliged.
So we have reached 90%, 10% is blanks.
The crucial 10%.
Item numbers 7 to 10.
My lord, similar order can be passed.
What happened here? This is also CHI?
Yes, my lord, it's all
Same,
covered.
same part.
Same.
Same, madam?
My lord, all the cases that is included is tabulated in the letter that I have
Okay.
provided, and all these cases are
23 of 19, 22 of 19, 27 of 19, then 28 of 19. Okay. A belekke mariba tumi edu. Item number 7 to 10. I got to 3 to 6, same order. Okay. Victor,
due
done.
obligement.
11 and 12 also, my lord.
Same,
Item number 11 and 12 also.
same.
Yes, my lord.
Tetiala 6 to 12 kori diba. Okay.
Deeply obliged.
Item number 13.
Keep this inside, that early one. And Xerox it and also keep it here. Yes,
Yes, may I please, Your Lordship, my lord, let me take Your Lordship to the background of the case, my lord.
this is item number 30.
13, my lord. This case arises because there is one airship matter pending at the lower court. And the respondents have filed an application under Order 39, Rule 1 and 2, for collecting rent.
There was a will.
Yes,
What happened to that will?
but the will was not probated.
Then?
And one airship certificate was issued to my mother, despite the presence of will. Then,
Now, why is the will not being probated? Everything will be resolved.
but my lord, my father has write one will. Despite that, my mother had obtained a separate airship certificate in respect of my father's property. And now my mother is dead.
Dead.
Yes. And therefore, I obtained airship
Who are
certificate.
the respondents? How are the respondents related?
The respondent number 1 is my sister, and the respondent number 2 and 3 are my nephew and niece, my lord. We are all family. That is why I approached this honorable court, because at this stage, my lord, letting them collect the rent without recoursing to any other means would mean that they
You mean to say that by allowing them to collect the rent, some
Yes.
rights accrue to them?
Yes, yes. It would assume that they would assume that some rights accrue to them. So my humble submission at this stage is that let the rent be deposited at least before the court before the until final disposal of the case.
But I think I have seen somewhere that they were collecting this rent from much before.
Yes, my lord.
No, my lord. To that submission, I have made. If I take your lordship to my
I think that statement is there in your,
yes. Page
and
36 of my petition.
there was an earlier proceeding
Yes.
wherein you have not
Yes.
raised these issues.
At the time of that, due to my, the respondents have filed one RFA.
You have filed an affidavit there,
Yes.
and then
No, I have not filed an affidavit in opposition in the in RFA number 32 of.
no, writ petition number 61.
No, that was filed entirely on different matter, my lord. The reason for filing that writ petition, if I take your
Now,
lordship-
in terms of that will,
yes,
say I am probating that will today, then they also get a share?
yes, my lord.
The area from where the portion from where they are collecting the rent would fall in their,
But that will was
Yes,
not probated.
yes, my lord.
would fall in their lap, right? Say today the bill is probated, let's
Yes,
say.
yes.
Then in that situation, say you have a 3-story building. You have been given the ground floor, and they have been given the first floor and the second floor. Today they are collecting rent from first floor and second floor. But that situation would, when the will is probated also, that will be with them only.
But my lord,
Have you disputed that will?
No, my lord, that will needs not be disputed because after my father died, without probating that will, my mother had obtained heirship certificate in connection.
Has anybody challenged that?
No.
Then
heirship
your mother,
certificate-
has your mother submitted has your mother made a will? No.
No, no. So my mother heirship certificate
No.
still stands.
In terms of your, that Inheritance Act,
Yes,
after the death of the father,
yes,
the mother becomes the head of the family.
yes, my lord.
So she can have an heirship certificate to that extent.
Yes, yes, yes.
But the devolution of that being not her self-property, will be in terms of the will.
But my lord, the will
I don't
has-
know, I'm trying to understand.
Yes, yes, yes. The will has no effect as of now. Because it
Difficult
was-
to,
Yes, it was not probated and being not probated after
show me the impugned order.
the impugned order is,
When did your mother die?
my mother passed away on
When did your mother die? When was?
just a minute, my lord.
The mother died on 19/3/2015, my lord.
19?
3/2015. My lord, the reason is that my friend's submission is not entirely true. The heirship certificate issued to the mother was challenged by her during her
2010.
lifetime. Yes, by filing a writ petition. And ultimately she withdrew. And when the mother died, she tried to grab everything for herself. That's when the problem started. During the lifetime of my mother, everybody was enjoying
Where
the
is that,
property.
her statement in the writ petition about your father's will and the devolution of property therefrom?
My lord,
Page 28 of your,
yes.
Before that, my lord, if I take a lordship to page 24 of their objection, my lord, at the last para, page 24 of their objection, that synopsis part, the last para, that is the main reason why I filed the writ petition.
my mother and your sister were trying to
Yes, yes,
mortgage
yes.
that LSE.
Yes, in order to protect that property.
So that,
And in the next paragraph is the reason for
No.
filing this instant writ petition. To constitute.
that situation is no longer there, that is gone.
Yes,
So heirship certificate was given to your mother.
yes, my lord.
Now also it is in a limbo, it's not functioning.
Yes.
No, the forum is not functioning now.
The forum is functioning. In fact, my lord, the trial court has passed an order, the impugned order which they have challenged. But till date, they have threatened the tenants of the building and they forcefully collected the rent. And a proceeding under Order 38, Rule 2A,
Violation.
has been initiated by the court against her.
My
Mr.
Lord,
Counsel,
So, my Lord,
make up your mind. If I get into, it may even harm your defense.
that is why my submission is that let the rent be submitted
No.
before the court, my Lord, before disposal of the case.
I'm not satisfied that the order is wrong.
And the reason for filing that, as I have said, my Lord, filing that said WPC is for constituting the district council court, my Lord, at that relevant time.
But statements made therein will have some bearing, Mr. Counsel. You can't make,
Yes.
these are affidavits. Affidavits on oath, statements made on oath. We'll say that this will not give them any right,
Yes, my lord.
and it will be dependent on the final order.
Yes, my lord.
Two options to you. Take that order or take an adjournment, whichever is suitable to you.
Yes, my Lord, I'll seek an adjournment. And before that, my Lord, before that, let the lower court records be called.
No,
There is-
no need. We are not troubling our registry.
My lord, let the
Lot of
order be
it case.
passed. It's pending for quite a while. In fact, they are delaying the trial court due to this FAO, my lord.
There is no stay order.
There is no stay
my
order,
lord.
my lord.
Had the Lanark Council, Mr. So-and-so, Lanark Council for the appellant, as well as Mr. So-and-so. You are there? Mr. Subedi, you also there? No. Appearing for the respondent number,
All the respondents, my lord.
all the respondents. Full stop. As prayed for by the Lanark Council for the appellant, the registry to list this matter on 25/3/2024. Full stop. On the next date of listing, as agreed to by the parties, the matter would be taken up for final consideration. Full stop. The Lanark Council for the respondents have submitted that on account of pendency of the present proceedings, इसको ऊपर में लिखना, on account of the present pendency of the present proceedings, the trial court is not proceeding with the matter.
It's proceeding somehow, but they're using this as an excuse.
कर दो. नहीं चाहिए आगे वाला रहेगा. Somehow,
Item number 14.
Mr. Counsel, sorry, I may have got you wrong, but this is my understanding. Can't help it.
My lord, the thing is that they have seek for time over and over again due to this pendency. That's the reason, what I'm trying to say.
When is the next date?
The next day, I am not sure, but it will be in the next month.
Okay, 25th we have fixed it, so no order.
Item number 14.
Yes,
Lordship, in this case, I'm representing all the respondents.
revenue is
Lordship.
not filing any appeal?
Lordship,
Any-
I have received the instructions from the department. I
You
may
have
be
not?
Yes. I
You
may
have
be.
received?
Yes, I have already received. I'll be filing within a week, Lordship. Within 1 week.
What happened to the other matters?
My lords, it's still pending.
Pending.
Almost.
But there was a division bench order in this line also. Just check up,
Yes, my lords.
my Lord Justice, Chief Justice's order. Just
Yes,
check
yes,
up.
my lords.
Mind
Recently,
me.
I've heard of that order.
I think I was also a part of that bench. I just forgot. Just forgot.
So, my lords, as such, the amendments have already been incorporated.
Incorporated. Yeah. So you're basically with GSTR 3.
Yes.
The population,
Correct.
population maintaining. Mr. So-and-so, you are Jordan.
John,
नाम लिख लेना दोनों का, हाँ? So-and-so. The Lanark Council for the respondent submits that he has, revenue submits that he has received the instructions from the respondents and would be filing the affidavit on or before. Give me a date.
Lordship.
Take your convenience, but don't overshoot that date.
Yes, Lordship. Before 21st of this month.
Okay, on or before 24/3/2025. The petitioner is at liberty to bring on record his rejoinder thereto on or before 4/4/2024. Registry to list this matter again for admissions on 22/4/2024. Right?
Lordship, in this matter, the registry may be directed to reflect my name in the course list, Lordship. They also have
Name of Mr. So-and-so, Lanark Council for the
all the respondents.
all the respondents. Registry is directed to reflect the name of Mr. So-and-so as the counsel for the respondents in the cost list.
Lastly, my lords, interim stay, my lords.
Interim order passed earlier to continue until further orders.
Grateful.
Item number 15.
Yes.
My lord, the present matter is taken as a fixed item. But my lord, I'm seeking your lordship permission to withdraw the present appeal due to technical reason with the liberty, my lord. My lord,
There is
the
no
thing is that
technicality. Okay, fine.
technicalities
It's up
that
to
my
you.
lord, technicalities that my lord.
Why don't you finish it off? Why you come back again?
Thing is that my lord, here as per the Mizoram Civil Court Act, my lord, the district court has the authority to take up the first appeal if the pecuniary value.
Okay, you mean to say jurisdictional error?
Yes, yes, my lord.
Mr. So-and-so, learned counsel for the respondent, for the appellant, submits that he be permitted to withdraw the present appeal with liberty to approach the appellate forum in terms of the provisions of the Mizoram Civil Court Act 2005 as amended.
My lord.
Right?
My lord.
Full stop. Prayer is not objected to by the learned counsel for the respondents.
Still,
Full stop.
no counsel, my lord. Counsel is not.
Oh,
still,
no, full stop. In view of the above submissions, the present writ petition stands dismissed for dismissed on withdrawal with liberty as prayed for.
Deeply obliged, my lord.
Item number 17.
My lord, I'm appearing for the appellant, my lord. My apology to be appearing online.
No problem. This is a permissible mode now.
Please, Your Lordship.
My lord, I just filed my power for CBI respondent.
Okay.
This is the third time they have been seeking for
No,
instruction.
they have
also,
filed the
but
power
till
today.
date.
That is final, they have filed the power. So,
Your
what
Lordship,
do you
on the previous
want?
date-
We'll have to take this up for hearing.
My lord, the LRC
Lower
case
court
record
records
may be
have not
called
come.
for. Yes.
It's been called for, it's not come. It's come, it's come.
It's here. Come to me.
Full stop. We'll have the paper book ready.
Please, Your Lord.
May I have your name?
Prang, P-R-A-N-G, Prang Newmai. My lord, I
Prang.
have put it in the chat box, my lord.
Huh?
I have put it in the chat box, my lord. Chat box.
Okay. Heard Mr. P. Newmai, N-E-W-M-A-I, learned counsel for the appellant, and Ms. Swenson, learned counsel, appearing for the respondents. All the respondents?
Yes, my lord.
All the respondents.
There is only one respondent, CBI.
For the respondent. Full stop. Central Bureau of Investigation. Full stop. Accordingly, service of notice upon the respondent is complete. Full stop. The office note reflects that the lower court records in original have been received. Original court records have been received. Full stop. Accordingly, registry is directed to prepare the paper book and furnish the copies of the same to the learned counsel for the parties. Full stop. Registry to list this matter again after when?
My lord, as it pleases Your Lordship, Your Lordship.
How
If it is
long
for
does it
hearing, my
take to
lord,
prepare the paper book here?
It's ready, my lord. When paper book is ready.
No, how long does it take? So how much time normally? 1 month? 1 month. Registry to list this matter upon preparation of the paper book after, list this matter after 4 weeks. Full stop. In the meanwhile, the paper book be prepared. Full stop. Matter be listed on the returnable date for admissions. Oh, for hearing.
my lord, if my lord is listing it for final hearing, my lord, if my lord can give us some date, because we are from Delhi, so we have to even book the ticket. my lord. So that is the
We'll
point.
have one more date for orders, then we will fix the date for hearing. The paper book has to be ready. For
Please, Your
orders,
Lordship.
for orders, huh?
Much obliged, Your Lordship.
Oblige.
Item number 18.
Yes, are you filing objections?
My lord, I have filed today.
Today. Have you got a copy?
Yes, my lord.
Your Lordship, with regard to respondent number 7 to 9, 11 to 13, I may be allowed to file within 2 weeks' time.
I mean, given time.
Some
Roshan Subedi, Learned
Yes.
Council, this was given 1 month back.
I'm in the process of applying some copy of orders from the lower court. So once that is there, I'll file immediately, Your Lordship.
Mr. Victor Aralte.
I am for the respondent number 10.
For the respondent number 10 submits that he has filed his objections today.
Today.
Full stop. Mr. R. Subedi, Learned Counsel, appearing for the respondents number 7 to 9 and 11 to 13, submits that the affidavit on objections on behalf of the respondents would be invariably filed before the next returnable date. Madam, you are appearing for the government.
Yes, my lord. But however, I will not be filing my objection.
Ms. So-and-so, Learned Government Advocate, submits that no objections on behalf of the government respondents shall be filed in the matter. Full stop. Accordingly, the registry to list this matter again on 2/4/2024. In the meanwhile, the pleadings shall be completed by the parties.
Item number 19.
May I please, Your Lordship?
Yes, Mr.
Yes,
Monson.
Lordship, this is an application.
Onerous conditions.
My Lord.
You are for?
Applicant, Lordship.
My Lord, the
What is
applicant is
this?
from Assam, my Lord.
This is an application under 301 CRPC for participation, Lordship.
You assist who is bothering you. This is between me and the court, me and the accused. He is only here for, he is not here for a bail or something. He is here for bail has
my
already
lord,
been granted.
Yes, in
The conditions.
No, my lord.
The conditions is.
No, actually, my lord.
Is there any other prayer made by him? It's only for modification of the conditions of the bail.
No, yes, no, my lord.
Again.
There are two petitions, my lord, now pending before your lordship. Number one is that they seek for quashing FIR, your lordship.
Yes.
Number one. Number two is that they seek for modifying the condition of bail, my lord.
No, I'm with the condition of bail. Modifying we will see, squashing we will see.
And that also, my lord, now since I'm the victim of...
You are not a victim.
Yes, your
in
lordship.
this, that sense of the matter.
Yes. So, my lord, if I may kindly be allowed to participate, my lord.
Give me the second one. Criminal petition, second one. Mr. Mahajan, the condition, bail conditions, you are challenging in criminal petition 2.
My Lord, exactly, my Lord.
Yes, who is appearing for the state? Yes, madam.
My lord, we do
You
not have
give
any
a bail from one hand, take it away from the other hand.
Actually, yes, if I may, lord.
Yes, madam, what do you say?
Are
you
My lord,
ready?
with regards to the application filed by my learned friend, I do not have any serious objections.
No, we are not considering that. It's between you, me and the court and the accused. That's all. What do you say about this application for modification?
Application for modification, my lord.
If I may, lordship, today is fixed for the IA only, my lord. IA.
We are taking
not on the main. For the main, my lord. If I may.
Whatever is before me, I can have it. Don't worry.
No, my lord.
So the
my simple.
I
prayer,
have
my lord.
removed the cover. So I am with the meat of the matter now. Let them satisfy me whether this should be modified. What is the amount involved in that FIR?
About 150 crores, your lordship.
I think there is a assumption.
Now trial now is, my lord, going on. So actually, the sum involved is quite.
The trial is underway. Trial is underway, madam. Charge sheets have been filed here.
Trial, my lord, trial has already commenced, my lord. Before the CJM, my lord. So now actually, my lord.
Mr. Mahajan, what is the stage of the trial?
My Lord, to my knowledge, my Lord, as has been told to me, my Lord, with all respect, my Lord, charge sheet CS has been submitted, my Lord. In this case, even CS has not been submitted.
Charge sheet has not been submitted?
No, my Lord, during investigation, my Lord.
What is the date of your arrest?
My date of arrest is, my lord, with all respect, my lord. I'm taking a minute, my lord, with all respect, my lord.
11/6.
My lord, 11/6.
So
My
bail
lord,
was
my
granted
lord, may I
on.
interfere, my lord?
Date of
This is a
arrest
default bail,
11/6/24.
Mr. Mahajan, is this a default bill?
No.
Default
Already
bill?
granted, my lord, yes, my lord.
167?
Yeah,
Default bill?
yes, my lord. Yes, my lord.
Madam, what do you say? If you are you ready? We'll take up the matter for final.
My lord,
Because this cannot wait. This cannot wait. A man's liberty cannot be done in this.
I understand, my lord. Problem is that, my lord, since the matter is fixed, IA is only fixed today, and I am a little bit handicapped because I do not have the reports with me. If the matter can be fixed, my lord, tomorrow.
Supreme Court decisions are there.
Exactly,
You
my lord.
give bail and at the same time you put onerous conditions, failing the accused to go on. You give him liberty, but you, with one hand, you snatch it away with the other hand. This is not done, man. This is not done. He may be, there may be enough material against him, and this is not a money suit. Madam, this is not a money suit.
I understand, my lord. I'm a little bit.
Okay,
I
when?
cannot
Give me a
comment.
date. Give me a date. This week or this week to one day, tomorrow.
9th of
On
April,
Monday.
Lordship.
Monday. We are not considering your. Let it be there. Mr. Mahajan, we are not considering. We are going straight to the appeal. If he wants to assist the PP, he can assist the PP. There is no problem. As an informant, he has that power. But here, Mr. Counsel, it is not grant of bail. Bail grant satisfaction already drawn. There is no allegation that, there can be no allegation that he has violated some condition of the bill because he is not out till now. So where is your right accruing to have any objection? Madam will have her say. We will hear Mr. Mahajan and we will pass orders.
There is a judgment from the Supreme Court, Lordship, saying that in
Mister, don't bring that. That
we
is
have
in a
the right to
different
be
context
participate.
altogether. That is in a different context altogether. You are not a victim. You are not a victim here. You are an informant. Fine. We'll give you that audience as an informant through the AG, through the PP. You can assist the PP. No problem. Am I right in saying so, Mr. Mahajan?
Possibly, Lordship is correct, my lord, to my knowledge.
Possibly. That possibly from Mr. Mahajan is very
My lord,
dangerous.
my lord, there's no
That
language, my
from
lord.
Mr. Mahajan is very dangerous. I'll have to be careful now. Miss
My lord,
Mary,
I'm
when?
sorry for causing the convenience because.
It's a question of convenience. Because here what I've seen is, it's not a question of grant of bail or for cancellation of bail. If that was the situation, we should have heard him. But here it's only for modification. Mr. Mahajan, just to understand,
Yes,
what
my
would be the appropriate condition according to you?
My lord, only thing
Given
is
the
this, my lord-
background of the
I'll
of the
not be
charge
on that.
involved.
Lordship is correct, but as has been told, here, my lord, may I just place two lines, my lord? That here, to my knowledge, there are 3-4
Mr. Mary,
cases.
we are just trying to understand the matter. We are not taking it up for disposal. Don't worry. Yes.
My lord. Here, my lord, with all respect, my lord, on the same subject matter or on the same series of, my lord, criminal activities involved, my lord, several affairs have been lodged. That itself is not in consonance with the Indian criminal justice delivery system. That is besides the point. Here, my lord, as has been told to me by my friend, my lord, that here the subject matter is pecuniary amount, my lord, with all respect, my lord, 150 crores. To my knowledge, in this case, only one vehicle, my lord. So quantum, 50 lakhs, no man will come out ever in his lifetime. He is only, my lord, more sure man will carry him out, my lord.
The submission of the learned counsel is a wholesome submission considering the area, the cases where you are involved. He is not making this submission only for this, because this is not the only case. There is a series of cases here and in Assam. ED is also there involved. I have got a matter last time when I come. ED is also involved in these matters. Okay. So 50 lakhs, according to you, only that is the condition objection?
No, my lord, another one, with all respect, my lord, that local surety is already not in, my lord, they are not acting, it cannot be done, my lord. Local surety, that to Mizoram government official, that too from Aijal, not only onerous, my lord. That can never happen, my lord.
That we
should
can,
never happen.
that we can make it, we can omit that part with regard to government and make it
My
a
lord.
local surety. Because
Local
it's the,
surety.
whether you will appear or not. And the other accused, are they there, ma'am, or they have all gone?
No, he has other co-accused, my lord.
Ah.
He was granted bail. It came out, they came for cancellation. The High Court, my lord, with all respect, my lord, my lord, with all respect, my lord, the earlier order of is operative, my lord. High Court
They are participating.
My lord, this is during investigation, my lord.
Investigation.
Definitely they would participate, my lord.
Okay. As consented by the learned counsel for the parties, the criminal petition number 2/2025 would be taken up for final consideration. Full stop. However, Ms. Mary L. Khangte, learned additional PP, submits that she has certain personal inconvenience today to argue the matter and accordingly prays that the matter, Mr. Mahajan, Monday?
Any convenient date, my lord, I'm happy, my lord.
On 17, madam, will you be fine, Mr. Madam, 17th?
Yes, my lord.
17, on 17/3/2025, full stop. The interlocutory applications, the interlocutory application being I bracketed criminal number 9/2025 would be considered along with the consideration of the criminal petition 2/2025 as agreed to by the learned counsel for the parties. Accordingly, registry to list this matter again on 17/3/2025.
If I may, Lordship.
No further adjournment would be granted in the
If
matter.
I may, my lord, if I may make submission, my lord. If it may be taken up on 18, because I have difficulty on 17, my lord.
No problem. 18.
No problem.
Madam,
Fine,
18, no
fine.
problem.
Deeply obliged.
18, no
Deeply
problem.
obliged, Lord. Deeply
My
obliged.
lord, my lord.
I would have taken it up today. Madam Mary does not have the record, so I don't want her to be handicapped here.
My lord.
Criminal petition number 1/2025, may likhna?
Same date, can it be, my lord, because
Let it list it along with criminal petition number 2/2025 on 18/3.
highly obliged, my lord.
Obliged.
Obliged, my lord.
Come on, we finish it up.
Item number 21.
May it please your Lordship, I'm appearing on behalf of the applicants. Your Lordship, by filing this application, the applicants have sought a continuation of 433 days delay in preferring the connected appeal.
Okay. Heard,
and-
madam, your name?
Miss Lalnun Louis, Your Lordship.
Learned government advocate?
Yes, Your Lordship.
Learned government advocate appearing for the applicants. Full stop. The present application is been filed for praying for continuation of a delay of 433 days in filing the connected appeal against the judgment, against the order dated 29/2023 passed by the additional district and session judge Champai district in LA case number, present LA case number 3/2025. Full stop. Issue notice. Full stop. Applicant to take steps for service of notice upon the respondents.
Your Lordship, if permission may be granted to serve the notice by dusty mode through the registry, Your Lordship.
To take steps for service of notice upon the respondents by way of registered post with AD as well as by way of dusty mode routed through the registry of this court. Full stop. On effecting service by way of dusty mode, the applicants would file an affidavit to the effect, above effect, registry to list this matters again after 4 weeks. So within the next 4 weeks, you get that.
Yes, Your Lordship. Much obliged, Your Lordship.
Yes, appeal.
My Lord, we are here for part 2, item number 12.
We'll finish it off.
Yes, my Lord.
Oh, he is not here.
His file is here.
The file can't speak for itself, unfortunately.
He's outside. My Lord, can it be taken after break?
Okay, 2 o'clock.
My Lord, obliged.
Hearing list, item number 12.
May it please Your Lordship.
Yes.
Your Lordship, this is an appeal against the judgment and order dated 17/10/2023, passed by the member cum presiding officer, MSCT, Aizol in MSCT case, 19 of 2020. Your Lordship.
Appeal dated, appeal against order dated 17/10.
17/10/23. In MSCT case number 19 of 2020.
By the MSCT Tribunal, Aizol.
Yes, Lordship.
Yes.
Your Lordship, in the instant case.
You are United.
United India Insurance Company Limited, Your Honor. Your Lordship, in this case, there is an accident on 22/1/2020 at around 10:20 p.m. And two vehicles were involved. One is a truck, and the other one is a Yamaha bike.
Accident on 22/1/2020.
22/1/2020.
And truck is insured by you.
Truck, yes.
Bike by?
Bike is against the National Insurance Company. That is respondent number 6.
In result of that accident, what happened?
Your Lordship, the rider of the bike died at the spot. So, Your Lordship, if I may be allowed, I would like to read out the charge sheet of the instant case. Charge sheet is at page number 26 of the LCR. May I read it, Lordship? Brief facts of the case.
Just a moment.
Yes. Page 26.
What was the police case number?
Lordship.
44 of 2020, ma'am.
That is the charge sheet number.
Is
No,
all
44.
That FIR number 44.
That
of
is the
20.
case number here?
Yes.
Aizol PS case number?
Yes, Aizol PS case number.
Aizol, what is the police station? Aizol?
Yes, Aizol police station.
Okay. And charge sheet submitted on?
19/3/2020. Lordship. Brief facts of the case. Page 26. The story of the case for prosecution is that on 23/1/2020, at around 10:55 a.m., a written inquiry report submitted by Police SI F. Ramzawa of Aizol PS to the effect that on 22/1/2020 at around 10:25 p.m., while he was performing duty at the PS, telephonic information was received from traffic control rooms stating that there was a road accident at Chanmari, Chaltlang Road, and one unidentified bike rider died at the spot. Pursuing the information, he and party rushed to the spot to inquire the matter. On reaching the spot, the deceased was found lying on his back below the truck, bearing registration number NL01/2020 AB 3627. The incident occurred that around 10:20 p.m. The deceased person, identified as C. Laramdin Sanga, 35, son of Lalzombiana of West Highland, was proceeding towards Chanmari from Chaltlang with his bike Yamaha MT-15 bearing registration number MZ01T1103. While reaching near Zote Honda, one truck bearing registration number NL01/AB3627 was moving in opposite direction. While passing one another under heavy traffic movement, the bike rider fell down from the bike and the truck ran over his body, as a result of which he succumbed to his injury. The truck driver fled away before the police reached the spot. Inquest over the dead body was held and found injuries of fractured skull, bleeding from nostrils and ear, and fractured rib cages. As the relatives of the deceased requested to conduct PMB at West Piling PHC, the dead body was handed over to Michael Laramsanga, West Piling Welfare Secretary, after consulting superior officers. In this regard, the OC West Piling PS was requested to prepare PME requisition and to do other necessary formalities. He requested to register against the truck driver under appropriate section of law. Hence, ISO PS case number 44 of 2023, dated 23/1/2022, under section 304A/279 IPC has been registered and duly investigated into. During the course of investigation, the complainant was examined and recorded his statement, which was similar to the content of FIR. He revealed that he had seized the involved vehicles, that is, truck bearing registration number NL01AB3627 and bike Yamaha MT-15 bearing registration number MZ01T1103 with their documents in presence of seizure witnesses, and the same were kept in the police Malkana, White Malkana registration number 33/20. Both seized documents were found cleared and valid in respect of insurance and other vehicular taxes. He also drew sketch map of the PO. On 24/1.
Okay,
yes.
you can proceed. The only thing is that he was said in page 27 that the truck driver should have been a bit more cautious.
Yes.
If he was cautious, this accident could have been avoided. And
yes.
that statement you will have to read with the statement of the driver when he said that two trucks, a truck and a bike, were coming from opposite directions,
Yes.
racing, and they were stopped. Right?
Yes.
And when the jam opened, he
Yes.
proceeded.
They
Next.
proceed.
Next.
And so, in this regard, Lordship, what I would like to point...
The truck was proceeding towards Changlang. He was proceeding towards Chanmari.
Yes.
And the bike was... The truck was towards what? He was proceeding in the same direction. Both
No,
truck
in the opposite direction. Yes.
Truck was proceeding towards?
Chaltlang Road, and the bike was proceeding in the opposite direction.
Then?
Your Lordship, this paragraph is relevant, I think. On 24/1/2020, requisition of mechanical inspection of the involved vehicle was sent to DTO Aizawl and
We have seen it, don't worry.
Yes.
We have seen it. The statement of the driver is recorded there. Then? And this was before the MACT court tribunal?
Yes.
This charge sheet was there? Before the MACT tribunal, this was placed on record?
Yes.
Then?
It was annexed in the claim petition.
Okay. What is the, have you raised an objection against that before the learned trial court? If so, what is the finding? So this is your only case? Is this the only point?
Yes, my main point, my main point is that there is
Then-
no proof of negligence on the part of the driver of the truck. Your Lordship, in the instant case, the claimant examined as many as 7 witnesses. 5 out of 7 witnesses.
No, we'll come to the witnesses. Finish this point first.
Yes.
Yes. Have you raised this point before the tribunal?
Regarding that,
That
charge sheet.
negligence, negligence, contributing negligence?
Yes, Your Lordship.
What is the finding?
Our written statement is at
Page 38.
page 38. Ground number 3 is court fee, regarding court fee. Number 4 is joinder of necessary parties. And para number 10. Para number 10 reads that as per charge sheet number 76 of 2023, dated 19/3/2020, which was enclosed in the claim petition, the deceased himself fell down from the bike and the truck ran over his body, which clearly indicated that the accident happened due to the rider of the bike. Moreover, he did not have proper driving license to drive his motorcycle at the time of the accident. Hence, the answering OP is not liable to the claimant at all. And under para number 13, police report oblique charge sheet enclosed to the claim petition is disputed as they are contradictory to each other. And under para number 14, OP number 1 denies the allegation of the claimant. OP number 1 is the appellant herein. That
Okay.
this is.
Okay, fine, got it.
Yes.
Then, next.
Yes.
So, was the issue framed on this? Where is the draft issues here?
Issues is at
Of the memo of appeal? In the judgment itself?
page 25. Under page number 26.
Okay.
Issues number 4. Whether there was fault on the part of the driver or owner of the accident vehicle.
3 and 4?
Yes.
Issues 3 and 4.
Oh.
So, what is the conclusion of 3 and 4?
3 and 4.
Page 48.
Third issue is whether the deceased had a valid driving license. The driving license LMT non-transport, although valid, it was not issued for the purpose of driving motorcycle. That is against the claimant. And fourth issue, para number 20. The fourth issue is whether there was negligence on the part of the driver or owner of the truck. From the evidence of CW number 7, VL Zomliana, who is the investigating officer in the instant case.
What is this LMB NT?
Light motor vehicle. NT means not transport.
Non-transport.
Yes.
The bike was used for, okay, fine, go ahead.
Yeah. Yes, actually the driving license.
You say that the driving license is for a light motor vehicle, not
Yes.
for a driving
It
license.
does not cover the two-wheeler.
Two-wheeler.
Yes. And the fourth issue, para number 23. Fourth issue is whether there was negligence on the part of the driver or owner of the truck. From the evidence of CW number 7, VL Zomliana. VL Zomliana is the investigating officer. Who stated that while passing one another under heavy traffic movement, the bike rider fell down from the bike and the truck ran over his body. He also deposed that the deceased died due to rash and negligent driving on the part of the truck driver. Hence, from the evidence adduced by his witness, the death of C. Laramdin Sang was caused due to the rash and negligence of the truck driver. The accident could have been avoided if the truck driver had cautiously driven his vehicle, as he was supposed to watch his side mirror carefully while passing with the bike rider. Besides, he had a chance to stop his vehicle before the fatal accident had happened. Your Lordship, in this regard, though this witness has stated that he could have stopped the truck driver, but yeah, there is no mention that the
Fine, I
driver.
got your point. Your projection with regard to the charge sheet is that it is not because of the fault. That's an interpretation you make of the charge sheet. It's not it is not because of the fault of the driver, but it's the fault of the motorcycle rider. This accident occasion.
Yes.
Right?
Yes.
But the charge sheet itself says that the truck driver should have been more careful.
Yes.
So negligence on the part of the truck driver is there.
Yeah.
And what
There
is
is
the error?
possibility.
What is the error here in this conclusion drawn then?
There is possibility that he could have been more.
Forget it. That is brought. That is decided by the. Show me how it is erroneous. Issue number 3.
Yes.
Issue number 3. Show me how it is erroneous conclusion.
Issue number 3, that the rider of the bike, he was not authorized to drive. He has no valid driving license to drive the
Fine, he fell
two-wheeler.
down. He
Yeah,
fell down.
He
It
fell
is
down.
not that he went and hit somebody. That plea could have been taken, but here he fell down.
Yes.
So he was not riding when he fell down. So
Yes.
the truck went.
Yes.
And the allegation against the truck driver is that he was not careful. So how can you be now divested of that responsibility to make the payment, compensation?
Yes. So Your Lordship, so that is a point. See, if the driver is fluent enough in driving, he would not have fall down.
Where is your material to support?
Your Lordship,
you have not brought on record anything before the tribunal in this connection.
Your Lordship,
you had adduced any evidence?
Yes.
You had given evidence? United India Insurance
The
Company
branch
had-
manager was examined.
What did he say on this point?
The evidence of the branch manager is at page number 86 of the
paper book.
SCR, Your Lordship. Your Lordship, may I read this evidence?
Just so.
Yes. Yes,
Come
Lordship.
to page 89. Cross. Point number 4. He is making this deposition in connection with the claim. But he says it's a valid driving license. And he has made his statement in examination chief only on the basis of the police report and the PME. He has not even alleged contributory negligence.
Yes, Your Lordship. But in
Don't say yes. Counter me. I want your counter on this. He has not even highlighted or indicated about contributory negligence. Then?
Yeah,
This is the only witness.
Yes.
Only witness.
Only the witness.
Then next.
And as per his evidence, Your Lordship, the medical officer who examined the deceased was of the opinion that the cause of death was due to head injury.
The truck went over him.
No, as per the police report, the charge sheet, the truck ran over the body, not the head of the deceased.
Let's go back. Now, this this charge sheet was accompanied by the PME report.
Yes, Your Lordship. No,
Huh?
Come
on, don't take this, huh?
PME report was submitted by the claimant.
Where? Page?
PME report is at postmortem 31. Post-mortem report is at page 31, and the relevant portion is at page 32, Your Lordship. Opinion of medical and health officers as to cause of death. Herein the medical officer has given his opinion that, in my opinion, the cause of death is due to head injury.
So this is part of the charge sheet. And the body means also the head. Body cannot be divested from the head, can it be?
No, it
It's
cannot
a single
be.
unit.
No, it cannot be, Your Lordship, because
Then
body and head
the
are
same,
different
it's
parts
part
of the body.
one transaction. Huh? So they say body, how can you limit it to
So, if
not
that is,
head?
Your Lordship, if that is the case, the medical officer has to be
Second
examined.
point, done. Third
Yeah.
point.
Your Lordship, the medical officer has to be examined to show that the body and the head
Why did you, where have you, who had produced this, exhibited this in the before the court? Who had exhibited this?
the claimant exhibit.
Claimant. Have
Yes.
you crossed him on that point? If you're getting technical, let us also get technical.
But Your Lordship, it is the duty of the claimant to,
Okay, I
to
understood.
prove the case.
Understood
Yes.
that he had placed this on record. So it became an evidence after his deposition.
But it is
But
a
just a
duty.
moment, client, I'm trying to understand. Show
Yes.
me if I'm wrong. So, to dispute that, you will have to dislodge that thing in his cross. Have you touched upon that in the cross?
Your Lordship,
You, as an astute lawyer, you are picking up things. That's a different thing altogether. But was it done there? Where it should have been done? Because the tribunal, MSCD tribunal had not ventured into that direction. That means there was no material. Where is your cross? Where is the claimant's cross?
yes, Lordship, the claimant is crossed at page. Your Lordship, all the claimants were examined. There are 5 claimants. So that examination may be irrelevant, I think. Yeah, because none of them are the, almost none of them did not visit the place of.
Need not be.
Yes.
They are there as claimants. They'll have to produce the materials
Yes.
to justify. Now show me that your cross.
Yes, Lordship.
NIC. Where is this cross?
Lordship.
You,
1, 2, 3, 4. Cross-examination is at page number 4. It starts from page number 2, claimant number 1. That witness was first cross-examined by the NIC, and after the NIC cross-examined him, the appellant.
No, I want a material to show that you had brought this aspect of to the notice of the claimants. That is the way you do it. If there is some inconsistency, you will have to comfort that witness with that. You had this material, why have you not comforted the witness with that? So that you could have elicited a response. That could have been considered by the trial court. Then we could have come in and give an opinion. But that was never brought, he was never comforted. That was allowed to be exhibited. Then, once exhibited.
But
anything more?
Yeah, because the claimant was expected to produce that.
Any decision in support of your case on this point?
From this point, Your Lordship, I have this. I would like to submit this citation, Your Lordship.
Yeah, please. And rightly said so, rightly concluded that driving license of the bike rider in the context of the case accident was inconsequential. So,
Your Lordship,
decision, what is the citation?
Your Lordship, Oriental Insurance Company Limited versus Mina Varial and others.
Versus Mina
Varial and others.
Cited, reported in
April 2, 2007, Your Lordship. SCR 2007-4 SCR.
Page?
642, Your Lordship.
Can you give me a copy?
Yes, Your Lordship.
This is for the proposition? What is the proposition involved there?
Your Lordship, the instant claim petition is filed under Section 166 of the MV Act. So in this case, the relevant portion regarding this judgment is at under para number 24, which is at page 659. May I read, Your Lordship?
Yeah, please.
Para number 24. We think that the law laid down in Minu B. Mehta and another versus Balkrishna Ramchandra Nair and another Subra was accepted by the legislature while enacting the Motor Vehicle Act 1988 by introducing Section 163A of the Act, providing for payment of compensation, notwithstanding anything contained in the Act or in any other law for the time being in force, that the owner of a motor vehicle or the authorized insurer shall be liable to pay in the case of death or permanent disablement due to accident arising out of the use of a motor vehicle. Compensation, as indicated in the second schedule, to the legal heirs of, or the victim, as the case may be, and in a claim made under subsection 1 of Section 163A of the Act, the claimant shall not be required to plead or establish that the death or permanent disablement in respect of which the claim has been made was due to any wrongful act or neglect or default of the owner of the vehicle concerned. Therefore, the victim of an accident or his dependents have an option either to proceed under Section 166 of the Act or under Section 163A of the Act. Once they approach the tribunal under Section 166 of the Act, they have necessarily to take upon themselves the burden of establishing the negligence of the driver or owner of the vehicle concerned. But if they proceed under Section 163A of the Act, the compensation will be awarded in terms of the schedule without calling upon the victim or his dependents to establish any negligence or default on the part of the owner of the vehicle or the driver of the vehicle. Your Lordship, in this case, the claim was preferred under Section 166 of the MV Act. So, the claimant are necessarily to take upon themselves the burden of establishing the negligence of the driver of the accident vehicle or the vehicle at fault. So, this clearly shows that the claimants are duty bound to prove negligence of the driver. Regarding
this is old one. Have the new one where 163A has been incorporated?
163A, no, they make a comparison between 166 and 163A.
It's 163, no? 164?
Yes, no, 166.
163A.
163A.
You have that? Well, my book does not have that.
There is an amendment. There is 164.
163 was brought about recently after that decision.
Once if that...
just see, 163A is there. 24, huh? When was the amendment? This decision is of 2007. It's an old decision.
Amendment is 2019.
19.
19.
You have that amendment with you?
Yes.
Why is it not here? No, it's only 163. Where is 163A?
One 163A has been repealed by the Amendment Act.
164 need. Now it has become 164 in the new Act, 163A.
Okay.
Now, my lord, we are only
So earlier it was
163A.
163A, that has become 164. Now it's okay, it's there. It's there.
It's same thing.
I have the old book if it is needed, Your Lordship.
Okay. Now, you have relied on this decision. Now
And
tell
there
me.
is, Lordship,
Tell
there is
me.
another
Another
decision, Your Lordship. I would like to. That is R.K. Madhur Yazid and another. Your Lordship, that the relevant portion is under para number 12, Lordship.
12.
Para number 12. May I read?
Yes.
Para number 12. In the suit, it was, is, the plaintiff who sought for a decree declaring the plaintiff number 2 as the owner of the suit land and the plaintiff number 1 as its sebite, and further a decree that they have the absolute right of possession and enjoyment of the suit land undisturbed by the defendants and their previous agents, apart from a decree for perpetual injunction and a decree for damages, etc. The plaintiff's claim title over the suit land on the basis of the factum that the suit land is recorded in the name of Sri Mahaprabhu, plaintiff number 2, installed and worshipped by the late Brahma Mayi alias Nangbi Maharani of Janmasthan, Imphal, and that she dedicated the suit land to the deity for its Seva Puja. Lordship, this is relevant. It was the plaintiff who came to the court for a decree as to its legal right, depending on existence of fact, which he asserted in the pleadings. The plaintiff, therefore, was required to prove about the existence of all those facts from a decree.
For a decree that the facts those were required to be proved in the case was the title so and so, installation of the event, so and so. And the evidence that the property really is delegated, it is a matter of evidence. Then?
And under para number 13, the last portion of para number 13. Although there was no requirement for dedication of any right, nonetheless the plaintiffs cannot absolve themselves from their responsibility to prove the essential facts of a valid dedication to the deity for religious or charitable purpose. The learned trial court duly addressed each mind to the respective contentions of the parties and therefore dismissed the suit for want of evidence in support of the case of the plaintiffs. Lordship, under para number 15.
Give me evidence act. Okay, got your point.
Yeah,
You
yes,
say
yes.
that the claimant in the proceedings has to establish that there was an accident.
Yes.
And the accident was caused due to the negligence
Yes.
of the offending vehicle,
Yes,
driver
yes.
of the offending vehicle.
Yes,
These
yes.
are the two aspects, or there is another aspect to be proved? These two aspects have to be proved?
Yes, it is the duty of the claimants to prove that case.
Okay. Now, how will the claimant prove that?
Because, Your Lordship,
No, claimant, how will he prove it? How can we say that a matter is proved? What is the evidence required for that, according to you?
I don't know, because...
You don't know?
Yes, because
You
it
have
is,
to-
yeah, it is because the duty of the claimants...
I know, I got it, we accept that proposition.
Yes.
But in this case, how will the claimant prove that there was an accident? Because none of them were there.
Yes.
So they are not eyewitnesses.
Yes, there are no eyewitnesses.
So how
And-
will they prove that there was an accident to that effect?
Yeah. They can produce the inquiry officer who conducted the accident at the spot, at the time of the
Need
accident.
not be, there is a charge sheet. If they can produce that charge sheet certified
Charge sheet,
copy.
yes, charge sheet was produced and the case I was examined, and the case IO
has brought on
as per
record
his evidence, he deposed on oath that he did not visit the place of accident, and his charge sheet was basically
that charge sheet.
Yes.
Charge sheet contains charge sheet that IO may not be there. IO will change.
Yes.
Do you get my point?
Yes.
The charge sheet is prepared on the basis of the case diary, materials collected. So that material revealed a particular fact that he put it in the charge sheet.
Yes.
In the inquiry examination also he said that. Now show me the cross that you had dislodged that. That is evidence,
Yes.
Mr. Counsel. Now that evidence has to be shown to be not proper. That is our onus is on you. Once he does it, burden shifts to you to establish that this is false. Have you discharged that burden?
Yes, yes, Your Lordship. But the case IO,
it is the plaintiff claimant who will have to establish his case. Once he has brought on record cogent materials, that will shift to you to disprove that. Have you been successful in doing that? No. These issues, your expert eye has seen it, but your people never saw this. You were maybe not there in the trial, were you? Were you there in the trial? Mr. Counsel, were you in the trial there? You conducted the trial.
No.
The trial was conducted by you.
Under the council, Your Lordship.
You were not there. These aspects you have now found out because of your expertise. But these aspects your colleagues there could not find out, unfortunately or fortunately, for the claimant.
Yes, yes, Your Lordship, but in this case, even the case IO himself has deposed that he did not visit the PO.
Sorry.
And
that is too technical a view.
And his report was based on the.
You show me a criminal case wherein the IO starting off had concluded and the man was not convicted. Every criminal case, there can occasion a case of a change in the IO. No, nothing. So he will proceed from, that's why they maintain a case diary. They don't store it here. They reduce it in writing. And from that, the charge sheet is prepared. Case diary is not relevant. But the charge sheet is prepared on that. So whether it's the IO, initial IO or the subsequent IO, how does it make a difference? So just picking one line of his statement, because he said that I did not visit the place of occurrence, he came in later. His statement says so, but that will not. Because you never crossed him on that. Did you cross him on that? See, Mr. Counsel, accident is proved from the charge sheet.
Accident is not denied.
The factum of accident, nobody is denying. It is only the manner in which the accident had taken place that is in dispute.
Yes.
So, he has brought the charge sheet, PME report.
Yes.
So, your objection is body head. That cannot be sustained. So, he has exhibited these two without any objection. So, the manner of accident was further proved from the deposition of the IO. That what had happened exactly. He has deposed from the charge sheet. You have not questioned that. Anything more?
Your Lordship, in this regard, if I may be allowed, I would like to submit one.
Please, you are most welcome to do whatever you. Yes. Don't mind my asking questions. That's my bad habit. What to do? That is my bad habit. I keep on asking something. That is my bad habit. Can't reform it now. Too late in the day for me. So you continue with your thing. Whatever you want to tell me, please be open and tell me. Please don't have any qualms. Please.
That is Sri Parmoyi versus Silal Thangbuna. Your Lordship, the relevant portion is under para number 10, page 9. In this case, the claim has been dismissed. Your Lordship, may I read?
Okay.
Lordship, para number 10.
I've gone through it.
Yeah. Lordship, para number 10, 12 and 16 may be relevant.
Okay. Anything more?
So, Lordship,
This conclusions of the coordinate bench is based on the facts of that case. But here there are better particulars. The postmortem report is there. The examination of the chief is there. The negligence has been highlighted. Therein, the truck had gone and hit a bitumen that, what do you call that, bitumen pit, wherein the bitumen was being diluted or liquidified. So that bitumen then fell on the deceased or the injured, whoever was there, for whom the claim was supported. Then it was said that the negligence of the driver's case was, I did not know that this was there. And that aspect was not dispelled by the claimant. And that's why the trial court as well as the High Court refused. Right? Okay. Anything more, Mr. Counsel?
Yes, Your Lordship. Regarding that, a medical officer, because he was not examined throughout the proceedings of the child, that are highlighted under ground number 5 of my appeal memorandum, which is at page 12.
But the charge sheet having been exhibited.
Yes, it has been exhibited.
So the the PME being a part of that. Right?
Your Lordship, as per the exhibited document, the cause of death was due to a head injury.
I got it. Body and head. Again, we come back to body and head.
Lordship, body and head cannot be
same.
Same, because there is body part and the head part. Body
Say
part and head part is different.
We go out from here. In the road, we find a person dead. Okay? What do you call it? If you come and tell me, sir, I have found dash there, what would that dash be? It would be a dead body.
Yes.
Right?
If you say like that, but if but the inquiry
No,
report,
that's why. Okay,
Yes.
I got it. But where is your? Once they have brought it on record, you permitted it to be admitted
Yes,
in evidence. Where is your?
We permitted it because there is a class of report because the findings were different.
And
because
these are public documents.
Yes.
You
Yes,
did
but
not have the author come. Certified copy of that will be enough.
Yes.
Charge sheet.
Yes, Lordship. But
am I right in saying so? Charge sheet. If you want to exhibit that, you can get a certified copy.
Yes, Your Lordship.
Order up to tomorrow. My order is exhibited.
Yeah.
Do you think mean that I'll have to go and give a deposition that yes, I have passed this order? My certified copy is enough.
Yes, that's correct. But
Okay, fine. Anything more?
Yes, Your Lordship. Regarding deduction.
30,000 was the projected thing, right?
Yes, Your Lordship.
So you have not disputed that 30,000 income? Have you?
Income was
30,000, I suppose?
Yes, my lord.
yes 30. Regarding that income, that was put under ground number 6.
My lord, at this stage, may I interject? My another friend is supposed to limit his defense Only under section 149 subclause.
There is a citation, Your Lordship, in this regard. I can produce regarding that.
Okay.
Ground number 6, page 12.
Okay. Got it. Then?
And another one is, Your Lordship, at page 14. Ground number 7. Deduction towards personal expenses. In my opinion, the 50% has to be deducted. But in the instant case, only 1/3 has been deducted. In this regard, the learned tribunal put reliance on the Sarla Verma cases. So I would like to submit this citation, Sarla Verma.
Para? Para, Council, para.
Wait, Your Lordship, please.
This is the way how you compute the compensation, right?
Yes, Your Lordship. Under para number 12, Your Lordship, page 169.
One half,
Yes,
50%.
50% has to be deducted because all the claimants were not dependent upon the deceased.
No, it said that if he's a bachelor, it will be 50%,
Yes,
right?
yes, it has to be 50%.
So what was done here?
Only
much?
1/3 has been deducted.
Okay.
The calculation part is at page number 55. Starting from page number 54.
Okay.
The deduction is shown under sub number 3, loss of income.
Done. Got it. Anything more? Okay, what do you have to say? Third point. Third point first, 50% reduction.
That point, my lord, I'll come.
Or you go by according to your convenience, no problem.
No, I'll come to the.
Your respondent number?
I'm the claimant respondent, my lord.
All four, all the 5?
Yes, my lord. I'll come to that, Sarla Verma. Para 31, page 136. SCC 2009-6.
Give me the paragraph. Just read the paragraph.
Para 31, page 136.
Huh?
Para 31, page 136.
How does the para start?
Where the deceased where the deceased was a bachelor. I have this online copy, my lord. In the meantime, may I read, my lord?
No, just a moment. It is under question number?
I'll just hand it.
Just give it to me once again. I'll just mark it here.
What I would like to stress at that point is that
Yes, give it back.
my lord, in normal circumstances, if he was a bachelor, 50% deducted should be done. But if your lordship will see, there's a condition in the absence of evidence to the contrary. So these exceptions will benefit my case, my lord. In the evidence which we have led before the trial court, the brothers and sisters, mother and father, they were all dependent on the income of the deceased. Even though the sister was earning and one of the brothers is earning, but it was not enough. So 50% deduction is not always in the case of a bachelor. If we read this carefully, because there was a condition. In our case, there is an evidence to the contrary. Had I not deposed in the trial court that I was dependent on the income of the deceased, 50% deduction is required to be deducted to.
That's the law.
Yes.
But 1/3 if you can show that there were dependents.
Yes. Now there is.
And what is the material? How was this issue considered by the trial court?
I'll take your lordship to the evidence, the judgment, madam. At page 52, my lord.
52.
No, let's come at 51, my lord, with your lordship permission, para 23. Page 51, para 23. I'll read this with your lordship permission.
Yes, please.
For computing the amount of compensation, the general principle of deducting 50% of the deceased's income in case of a bachelor is also considered. In the case of Salah Verma so-and-so, the general principle is to deduct 50% of the deceased income in case where he is a bachelor. However, it is decided that where the family of the bachelor is large and dependent on the income of the deceased, his personal and living expenses may be restricted to 1/3 and contribution to the family will be taken as 2/3 when the family is large, my lord. In the instant case, the claimants depose that they are dependents on the income of deceased, and this fact has not been rebutted by the opposite parties. Further, it is my opinion that 5 members, including the deceased, is a large family, more particularly in a modern Mizo family. For the reasons aforesaid, 50% income of the deceased is not deducted, and contribution to the family is taken as 2/3. So in a modern Mizo family, 5 members is considered to be a large family, my lord. Now coming to the driving license, my lord. I was possessing LMV non-transport. However, I had driven motorcycle. Now, supposing if I had caused a death to one person, then the insurance company would not be liable. I myself would be liable. Now, the vehicle which caused the accident of the present person, the victim here in Malot. The contract arose between United India Insurance and the driver of that truck. Now, the license of the driver of the truck is valid. So there is no question of whether he possesses driving license or not, because the contract against the deceased and the truck driver is third party. Even though if I may not have possessed any driving license, truck owner and the insurance are liable to my accident, which caused my accident.
You may even say that the accident was not when both the vehicles were in motion. Say both vehicle coming and colliding,
Yes.
then happening, maybe the driving license of the other person.
Yes,
would have-
my lord. And to that effect, my lord, National Insurance Co. Limited versus Suran Singh and others, here it says,
Citation?
2004, Volume 3 SCC 297. Para 110, page 341. I think this will repel the submission of my learned friend. Para 110, subclause 3, Roman 3. 4 lines from the top, my lord. 4 lines from the top. May I read? Mere absence, my lord, it starts with mere absence. Mere absence, fake or invalid driving license or disqualification of the driver for driving at the relevant time are not in themselves defense available to the insurer against either the insured or the third parties. So this is the decision rendered by the Honorable Supreme Court. In my case, I possess LMV NT, not a two-wheeler driving license. However, relying upon this judgment, mere absence, fake or invalid driving license or disqualification of the driver.
149 2A2 is there in the act now?
My lord.
It is there? You have, your book is with me?
Yes, my lord. Now, this would be between myself and NIC, not myself and
The United
India Insurance.
149, na?
149, 2A.
It is 3 here, 3A. 149?
2A, my lord.
Have you got it?
Yes, my lord.
What is it?
That there has been a breach of a specified condition of the policy being one of the following
It's
conditions.
rules.
No, it's Act, my lord. Section 149.
149 is like this here, so see.
It has to be the rules. Act, my lord. It has to be the Act.
Your book is of which edition?
This is the old Act which we are referring to. The old Act.
Old Act.
We are concerned with the old Act, my lord.
Okay.
We are concerned with it.
The accident is of? Accident was of?
2020, my lord. 22/1/2020.
And when did the new act come?
2019.
So it will be under the new act only.
Now, the provisions under Section 166, my lord, it came lately.
So on the date of the accident, this was not there. 88 was not there. Show me that one.
The case was filed on 7/9/2020. Accident arose on 22/1/2020. And amendment of MV Act 1988 is on 1st April 2022. 1st April 2022.
Amendment.
Yes, my lord.
Okay. So 149(2)(a) was taken away on the month of April.
Yes, amendment of MV Act 1988 is on 1st April 2022.
Okay, I'll find.
Now, my lord, coming to the point of the standard of proof required under the MSCT, my lord. I'll come to that. Bimla Devi versus Himachal, 2009, volume 13, SCC 530.
2009, volume 13, SCC.
SCC 530.
Okay.
Your Lordship will kindly come at para 11, page 533. And I'll also come at para 15. With your Lordship permission. While dealing with the claim petition in terms of Section 166 of the Motor Vehicle Act 1988, a tribunal stricto sensu is not bound by the pleadings of the parties, its function being to determine the amount of fair compensation in the event an accident has taken place by reason of negligence of the driver of a motor vehicle. It is true that occurrence of an accident having regard to the provisions contained in Section 166 of the Act is a sine qua non for entertaining a claim petition, but that would not mean that despite evidence to the effect that death of the claimant's predecessor had taken place by reason of an accident caused by a motor vehicle, the same would be ignored only on the basis of a post-mortem report vis-a-vis the averments made in a claim petition. Now coming to para 15.
Preponderance of probability.
Yes, my lord. Para 15, page 534.
Okay.
My lord.
Anything more?
My lord, with regard to the statutory defense available to the insurer, if your lordship may allow me to produce one judgment. National Insurance Co. Limited versus Nicoleta Rotagi and others, 2002-7, SCC 456.
2000?
2002-7, volume 7, SCC 456. Your Lordship may kindly come at page 468, para 16. For the aforesaid reasons, we are of the view that the statutory defense which are available to the insurer to contest a claim are confined to what are provided in subsection 2 of Section 149 of the 1988 Act, and no more, and for that reason, if an insurer is to file an appeal, the challenge in the appeal would confine to only those grounds.
Okay, fine.
My lord. My lord, in this case, the tribunal has not committed any error, and I beseech your lordship to uphold the judgment of the learned tribunal. That is my prayer, my lord.
Yes, anything in reply?
Yes, your lordship, in this regard, I would like to submit this regarding that 149. Your lordship, the relevant portion are highlighted, page 77.
This is for the proposition?
for the purpose of Section 170. The insurance company has a right to contest the claim because in this case, the insurance company has been arraigned as the opposite party respondent by the claimant themselves. So in that case, they have right to contest the claim in all available ground.
Not in appeal, but
yes,
you will have to have your foundation there. Para?
Para number 2, which is 776. 776. And
this judgment says that you can do it.
Yes.
The quantum can be questioned. It's not only that you will have to limit yourself to 149(2)(a). The quantum you can always question. That's the, I think, the proposition.
Not only that, Your Lordship. The relevant portion are para number 7, 8, 9, 10, 11.
But when he was making a submission, I did not give any importance because of this position of law only. You cannot be, when it's a suit or it's like a suit, you cannot be curtailed, right? Okay.
Yes, Your Lordship. I'm from the respondent number 6,
Huh.
National Insurance Company.
नाम ले लेना सबका.
Lordship, I have nothing much to say, and the interference of this honorable court is not warranted in this case, since there is no contributing negligence on the part of the driver of the motor, this motorcycle, Your Lordship. And Lordship, I have gone through all the evidences adduced before the tribunal, and there is not even a single evidence adduced before the tribunal that a contributing negligence is on the part of the rider of the motor vehicle. So, payment of compensation
has to be
proportionate. Yes, Lordship. And so interference of this honorable court is not warranted, Lordship, and it may be rejected, Lordship.
Pardon me, my lord. For my benefit, may I please with judgment?
It might be the benefit of the court also. Why are you keeping it so selfishly for yourself only?
Your Lordship may refer at paragraph 14, page 364.
Your decisions are 2004 3 SSC 297 for the driving license, standard of proof 2009 13 SSC 530, and no, statutory defense 2002 7 SSC. These are the 3 judgments plus this one.
Yes, my lord. I have also produced the citation, my lord.
I'm taking it.
My lord. My lord, you can keep that.
I can keep
Yeah,
this.
you can keep that.
एक काम करना, not carry this. Page 26, 26, 27. 26, 27, then 29, then 30, page 49 to 52. No, you can give me these evidences. 49 to 100. This file can be kept back in the registry, no? 49 to 100, that will do. Just make a copy, serialize it, and keep it along with this one. Heard the learned counsel for the parties. Full stop. Hearing concluded. Full stop. Judgment reserved. Full stop. The extracts from the original records have been taken, and the original records would be kept with whom? And the court officer to hand over the original records to the concerned dealing assistant for safekeeping. Full stop. And when this file comes back, connect it back. And if you want to make any written arguments, points, don't make it bulky. 4-5 page written argument, if you want to just bring it on record, you can give it to me by tomorrow. You can leave it with him tomorrow. Right?
Yes.
A second half, maybe I may not be here tomorrow, but you can leave it to him, he will get it to me. Judgment reserved, huh?
Obliged.
I'll only take this. There is any other second, third file here? You keep it along with that. And you mentioned this MSc appeal number there also. Hello? Thank you.
Thank you, Lordship.
And don't mind me asking. Habit, nothing deliberate.